Section 117, titled The Prohibition on Engaging in Sexual Acts While Acting Under Color of Law. This comes from the George Floyd Justice and Policing Act. They call this section the Closing Law Enforcement Consent Loophole Act of 2021. And it raises question about who can consent to sexual conduct while in custody. And the inspiration for this, the act originally came from a case where an 18-year-old woman in New York City accused two officers of raping her. And they argued that she had consented to it while handcuffed in the back of their squad car. And those officers were eventually, were fired and disciplined. But at the time, there was no restriction on those officers asserting that she had consented. And the Huffington Post reported last year that after New York changed its laws in 2019, 34 states still allowed for this consent defense. And so Section 117 would close the Law Enforcement Consent Loophole Act. And this really, raises larger questions of who can consent, who can give meaningful consent. What does that mean exactly? I mean, is it possible for someone who's incarcerated to meaningfully consent to a sexual relationship with one of the guards? It's possible, but it certainly raises a lot of other issues, like what happens if the incarcerated person wants to withdraw their consent later on, where guards have the ability to control large aspects of the lives of the people in their custody. It's really hard to say what is meaningful consent. And so in other areas of the law, like age, we've said, children under a certain age cannot give meaningful consent to sexual relationships with adults. And that same sort of principle would apply here. When someone has lawful authority over you, say you cannot give meaningful consent to participate in sexual acts. The courts have kind of taken a mixed position on this. Lower courts have recognized this as sort of being, could be a violation of the Eighth Amendment, cruel and unusual punishment kind of thing. But Circuit, Eighth, Ninth, and 10th Circuits, they've all ruled that there is a consent defense in allegations of sexual assaults. And once again, the courts and the executive action body can take actions, but it's the legislative branch who should really provide clarity and clear up what is the position of the United States. How do we protect people in custody? And that's what this section of the blueprint is. It aims to do. I guess we'll go into a little more detail about what exactly this does. And so there's a whole section under Title 18 dealing with sexual offenses. And so there are already a number of restrictions in place for people who are in custody. And the prison rape reform, I'm messing up the acronym, the Prison Reform Education Act back in the 90s also a lot of these issues as well. But as the case in New York City identified, there was still a big loophole for people who were, who had not actually been convicted of a crime yet, people who are under arrest or otherwise detained or incarcerated. And so this section 117 will broaden the umbrella of people who are protected by this by adding the phrase or otherwise acts under the color of law. So if you're asserting your lawful authority over a person, it'd be a crime to knowingly engage in a sexual act with another person that is under your custody. And in line with the existing law, it would allow for imprisonment of not more than 15 years or a fine. There are some defenses that are currently allowed Specifically, there's a marriage exemption. This would sort of override all of that and very explicitly say that in a prosecution, it's not a defense that the other individual consented to the sexual act. So this would establish very clear federal law that says consent, would get rid of the law enforcement consent loophole. So actually, the George Floyd Justice Act introduced a new loophole for sexual contact as opposed to a sexual act. These things are defined in the United States Code. A sexual act is defined as skin, physical contact, skin to skin contact in the mouth, genitals, or anus of two people, and any contact other than that was not included under the definition of a sexual act. It was just sexual contact. And the way that the Closing the Law Enforcement Consent Loophole Act was written, it created a new sexual abuse crime, but then didn't apply the prohibition on sexual contact to that. So it created a sort of a new loophole. Preparing this section for the Blueprint for a Better America, went through and updated, correct that, and closed that loophole so that, again, to protect people who are in custody from someone being able to assault them and then claim that they had consented. So that's the changes that it makes to the United States Code. And like many of the other sections of the George Floyd Justice Act, there is also a financial incentive for states to apply these same laws. And so once again, beginning in the 2025 fiscal year, states or other units of local government did not prohibit this consent defense, would not be eligible to receive funds under the COPS grant program. And so they'd be incentivized to explicitly make it a criminal offense for any person acting under the color of law to engage in such sexual contact or any sexual act, individual under arrest, in detention, or otherwise in the custody of law enforcement, and prohibit a person charged with such an offense from asserting consent as a defense. And would also require that there be a report to the Attorney General each year.
It sounded like you'd said that you had redefined either sexual contact or you redefined a term. Is that correct? In the legislation?
I didn't redefine a term as much as put the new criminal act in a different section of the law, so that it would that the prohibition on sexual, the way the law is written now, it spells out exactly what the sexual acts are that are prohibited. And then there's another section that says, well, if sexual contact would have been a sexual act, these scenarios, then it's a penalty. And the way that the George Floyd Justice and Policing Act wrote this section of law, the sexual contact penalties didn't apply because they only applied to enumerated sections. And when they created a third one, it didn't apply. So by tucking the offense into one of the existing sections, then that protection relating to sexual contact does apply. Does that make sense?
Yeah. So you're saying before there were like sexual contact was excluded in some cases, and it's now been adjusted so it's always included. Is that a way to understand it?
Yes. The way it was proposed for adding this protection for people acting under color of law, they proposed making it a separate offense. And by making it a separate offense and not including it, the sexual contact statute didn't point to it. They created a loophole. So
okay, just closing that loophole.
Yes. Okay.